In 1973, a young attorney, Sarah Weddington, only 26 years old, found a young woman who was pregnant and didn't want to be, named Norma McCorvey, and filed a lawsuit in Texas challenging Texas's very narrow abortion restriction law. And she actually made a lot of arguments. She made arguments based on the Equal Protection Clause, that women can't be equal unless they have access to full reproductive rights. But she also made arguments rooted in the right to privacy, that women have the right to make private medical decisions in consultation with their doctor. And the 9 white men on the Supreme Court in 1973 didn't really care about the equality issue, but they could kind of relate to the privacy issue, right? They could kind of relate to the idea that, you want to make medical decisions with your doctors without the government butting in. And while there's not an explicit guarantee to privacy in the Constitution, there are a number of amendments that talk about freedom from government intervention. Amendments like the First Amendment right to freedom to associate, and the Fourth Amendment right to not have the government search and seizure, the Fourth Amendment search and seizure clause, which just says the government can't just bust into your house and search around your house without probable cause. The Fifth Amendment, right not to self-incriminate, this idea that you have the right not to incriminate yourself, and that was sort of privacy. And then the Ninth Amendment, which basically says we're not articulating all the rights that you have, and there might be other rights. And then most importantly, the 14th Amendment right to liberty, and the right to, basically run your life without the government interfering in your life. So out of all these rights, the government, or the Supreme Court at the time, miraculously said people have a right to privacy where the government should not interfere. And it was based actually on a previous case involving contraception and whether a married couple could use contraception. It was the Griswold case, Griswold versus Planned Parenthood. It was a 1965 case involving a Connecticut law which prohibited married couples from using contraception. So that's when the court first developed this idea of right to privacy. In Roe, they expanded it to abortion. And they basically said, if the government infringes on this fundamental right to privacy by trying to restrict abortion, then the courts will weigh the interests of the state against the interests of the woman in privacy. And basically, they broke pregnancy down into 3 trimesters. The first 3 months, the abortion decision must be left to the medical judgment of the doctor in consultation with the woman, because the rights to privacy take precedent. But in the second trimester, the state has an interest in the health of the woman, so the state may regulate abortion in ways that are reasonably related to protecting maternal health. And then in the third trimester, the last 3 months of pregnancy, because the state then has an interest in potential fetal life, the state may regulate or prohibit abortion except where necessary in the appropriate medical judgment of the doctor for the life or health of the mother. So that was Roe. That's what Roe versus Wade said. And there was a companion case, Doe versus Bolton, which defined the health exception. They said the medical judgment may be exercised in light of all factors: physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient. So they defined this health interest pretty broadly. All of these factors may relate to health, they said, and this allows the attending physician the room he, quote, he needs to make his best medical judgment and operate for the benefit of the pregnant woman. So Roe versus Wade and the companion case of Doe versus Bolton basically gave the woman and her doctor a whole lot of leeway throughout pregnancy to determine when an abortion could happen. And the anti-abortion movement hated that. So from the very beginning, they began to chip away at it. And I'll talk a little bit more about how they did that early on by targeting low-income women. But I want to talk about Casey because Roe is actually no longer the law of the land, even though people talk about, oh, the court's going to overturn Roe. Actually, Roe has been severely restricted by a 1992 case called Casey versus Planned Parenthood versus Casey.